Please, Your Lordship. Your Lordship, I beg to mention item 9 of the hearing list. 9, sir.
Yes. Item 9.
Item 9, Your Lordship.
You are here in this case,
No,
no?
Lordship, I just want to mention, Lordship.
Mention about this case.
No, my case.
Your Lordship, I had informed the respondents.
On pre-made by the petitioner, this is matter of 2 weeks.
Your Lordship, let it come after winter vacation.
After 2 weeks means what?
Lordship.
Look
Highly
at the calendar.
obliged.
Hey, please, Lordship, I beg to mention item number 12, Lordship. It's a criminal appeal, Lordship. 12
After
of hearing list.
After vacation,
Lordship.
on pre-made by the appellant, this is matter of vacation.
Lordship. Much blessed, Lordship.
Please, Lordship, I beg to mention item number 7. I pray that this matter maybe we have to file. I pray some more time, Your Lordship. We have to file the.
This argument was already over and done with. Your Lordship had asked us to place some citations. So I have submitted on the last date, Your Lordship. Yes. I've given a. But they have not yet.
So
They are the
I pray for
petitioner.
time.
So, they are the petitioner.
They are the petitioners, exactly.
Yes, Your Lordship. So I need some time, Your Lordship.
After vacation,
After
Yes.
vacation.
on pre-made by petitioner, this is matter of vacation.
Highly obliged, Lordship.
Your Lordship, I beg to mention item number 10. Let it come after vacation, Your Lordship.
This is a matter about
Your service matter, Your Lordship, wherein we are challenging the impugned letter passed by the respondent managing committee. We were asked to undergo fresh interview in order to regularize our service even after serving for 20 years.
you are serving which school? School.
Yes, Your Lordship, in Hillview School.
That is the Assam regimental thing.
As in regiment.
On pre-made by the respondent Union of India. Matter is adjourned and not objected to by petitioner. That is adjourned. This is after 2 weeks.
After vacation, Your Lordship. After vacation, Your Lordship.
I said you calculate the date.
Yes.
Much obliged.
Invariably, it will come after vacation.
May it please, Lordship, I beg to mention item number 11, Your Lordship.
Item number?
11. Your Lordship, I pray if this matter may come up after 2 weeks.
No, Mr. Jha, what was your last instruction?
My lord, this was with regards to the promotion, my lord. So the respondent ought to have produced the 2 DPCs,
Okay.
my lord.
Since you have already got your promotion, but you wish to,
From the juniors, from the date when my junior has been promoted.
have you also read them as respondents?
Yes, my lord. I have added them.
But are they represented?
No, they have not. Even all the affidavits we have, some of them they have said that they have received, and they said they have reverted that letters. I have no objection to it.
Pre-made by the parties, this is matter of the vacation.
Much obliged, Lordship.
May I please, Your Lordship, I beg to mention item number 14, Your Lordship. Let this matter be taken up for vacation, Your Lordship.
You're for
I'm for the petitioner, Your Lordship.
petitioner. Have you seen? What is the case about?
It's a criminal appeal, Your Lordship. We are challenging the impugned
In
order
an appeal, is there a petitioner or an
on
appellant?
behalf of the petitioner.
Appellant.
Appellant, Your Lordship.
On pre-made by the appellant, this is matter of the 2 weeks. 2 weeks after 1, 2.
Much obliged.
Course list, item number 1.
Lordship, I was the holder of an arms license.
Have you?
We have served copy, Lordship. Last time
Who's appearing for state?
somebody was there from the state. Justice, thank you, had recused himself in this matter.
I think somebody should be there. Mr. Sarji, are you there?
I'll enter appearance. Today I'll enter appearance.
You've received notice there.
Yes.
But the brief is not with you.
No, I'll take it.
Somebody should be there.
I'll take it.
We could have disposed of this matter today.
But in the meantime, I'll get some instructions also.
Instructions? What instructions?
What is this about?
Arms license renewal.
So let it come up next week, my lord.
See, only the provision of the section 14 of the Arms Act is to be looked into, and we'll see how it goes.
14 and 17, Lordship. Lordship, I can give.
Let them file the counter.
I can give my brief.
But he is not. He will not be prepared. Heard, Mr. Here, Land Counsel for Petitioner. Mr. K.P. Bhattacharjee, Learned GA. Although he is appearing on behalf of the respondent, state respondent, has however submitted that the brief is not with him, and as such he could not make any effective reply in this regard. On premium, this is matter to 1 week. 1 week.
Obliged.
Item number 2.
Lordship will serve them an extra copy today.
You do that.
We please, Your Lordship. I pray if this matter may come up at the end of the vote, Your Lordship.
Nothing is there, miss. What is there? The records are there.
Your Lordship, the
Mr. Pandit, just you are here only on the ground of default bail.
Yes, sir.
And this is the calculation you have made.
Yes.
Your calculation is wrong. It's 179 days.
179 days completed on 19, and 118 days it is coming, Your Lordship. 180 days it's coming. May 2023, 8 days.
The order was passed on 20th. I mean, the charge sheet was taken cognizance of by the court on 20th.
20.
No court.
I also filed the application on 20.
So,
on 20, 181 days.
we'll take it up at the end of the board because it's just a question of calculation.
Yes, yes.
Daily costless, item number 1.
May it please your Lordship. Lordship, I have brought the case there.
What is this case about, Mr. Guru?
Here,
The stay is fixed for framing of charges, your Lordship.
my lord, this is a case where two of the accused were arrested by the police at Burnihart on the allegation they were in possession of heroin, my lord. One accused, my accused person, allegedly they seized about 33 grams, and from the co-accused 38. My lord, this case was charge sheeted in the month of June, my lord, and the charges are yet to be framed. Co-accused is already on bail, my lord. I am the only one behind, my lord, and I have got children, little children, and I have no other criminal background, my lord. So I am also relying on your lordship's judgment, my lord, and I believe I am squarely covered by that, my lord.
Have you?
My lord, I have applied supplied, my lord.
Where is the judgment?
It is on. I had supplied.
Okay.
So my lord, necessary order may be passed. This study is here.
We'll look at your complicity. Mr. Shulai, anything in the yes.
Lordship, the case diary is there, Your Lordship. It appears, Your Lordship, from the case diary that drug has been seized from the possession of the accused, Your Lordship. Even the statement of the witnesses also are here, Your Lordship.
I concede to that, my lord, because admittedly, my lord, 6 soap cases were being seized from both the accused. 3 from my accused person, 3 from the other accused person, my lord. That is the scenario, my lord.
I'll go to the CD and
my lord.
Deeply obliged.
The hearing on that, doesn't it?
Oblige, Your Lordship.
Item number 2.
Pass this one.
My lord, this matter fixed for admission hearing, in fact. My matter may come out of the application. It has related to the yesterday's lordship pronouncement, the same CMship. What happened, my lord, the respondent, Mr. Nongre, was appointed as a CM, and there was a complaint including the present petitioner. And in view of the complaint lodged by the petitioner and others, District Council placed him under suspension for a pending inquiry. And now, thereafter, my lord, inquiry officer was appointed by District Council without informing the petitioner, and inquiry conducted in the absence of the petitioner, and inquiry officer submitted the inquiry report without copy to the petitioner, and on the basis of the inquiry report, he was reinstated as a chief again. So therefore, being aggrieved, the petitioner had challenged the inquiry report as well as his reinstatement. And when we filed, there was no stay order, so he was continued to perform the role of as a chief. And later on, my lord, recently there was a complaint and resulted to yesterday's pronouncement, my lord. Now, yesterday matter is placing him under suspension. He is still a chief, under placing under suspension, subjecting to inquiry only. Now, in the event, my lord, if the inquiry that is going on now comes to conclusion that there is no material in the complaint, therefore he would be reinstated. He would be reinstated again. Then he will come back to the chair of the chief. In that case, my lord, my case pending now here is relevant. It is not infructuous. Therefore, may I pray at this point, therefore, Lordship may admit this one.
I think it's
Lordship,
you're just complicating the issue
with this subsequent suspension, Your Lordship.
As of date, I think this matter has no relevance.
Yes, it is infructuous, Lordship.
It pertains to a different period altogether.
Yes.
Madam, that is true. But now suppose if he is reinstated, my lord.
No, if he isn't, the scenario has changed. When he was, the incumbent, your grievance would have some relevance.
Right.
But subsequently, there was changed circumstances. He was suspended on one or the other, grounds.
Right.
That's immaterial.
Right.
But the fact remains that he is suspended.
Suspension.
And the inquiry is going on.
Right.
Whatever the case may be. As far as your matter is concerned, I don't see
any... It has
any...
superseded everything, Lordship. It has superseded the earlier suspension.
Superstition, different cause of
action.
action.
Can it be the two suspension orders?
Different cause of action. My lord, may kindly keep in mind, different cause of action. That is the reason, different grounds of complaint. Different subject matter of inquiries going on. My lord. Therefore, I'm not raising, my lord. Therefore.
And the allegations are identical, except for that
not
money
identical.
part,
not identical, my lord. If my friend said identical, then
you are the complainant.
One of the complainant.
Where is your complaint?
My lord, the complaint is also there. Lordship, can you see my challenge, the prayer portion, then quickly I'll come to the complaint thereafter. Lordship, can you come to page number 14. 14 of my petition.
Your prayer?
Well, page 14.
No, this is your prayer.
My prayer. Now may I come here? I sought for quashing of the inquiry report and his reinstatement, and seeking for de novo trial. Now my complaint is page number, my lord, 16.
16.
16, madam. Different nature of allegations. Different subjects.
Sum and substance, Lordship, is the same. They have challenged the rules.
It is not
there before this complaint. Regarding the...
Mr. I don't think you have a case.
It is different, madam.
If you have, if there are, if at all he is reinstated, and you have fresh...
yes, you can come against that inquiry report.
You file a fresh complaint.
My lord, in that case, my lord, if Lordship doesn't want to proceed the matter, as of now this, well, now, and my matter is closed, my lord. In that case, suppose my friend is reinstated.
You can come against that inquiry,
Well,
Lordship.
the question of delay, therefore, the question of delay last time also, my lord, I filed this 3 months of delay. Therefore, District Council filed an application questioning the maintainability. Lordship heard the matter, dismissed the application. That 3 months are not too long for citizen to come to reach to this Honorable Court. They take all this plea, my lord.
It is settled principle. You see, there is no issue of limitation as far as grid.
Right.
Though, see, it is not entirely.
Therefore, my lord, my humble prayer, my lord, inquiry may be completed very soon. So it may be taken up, my lord, after vacation. Even, my lord, fixed for hearing.
And while Leonard Friend is having a fear
just
that
clogging
he'll not
the
succeed
system.
in the inquiry.
Otherwise, my lord, may I humbly pray that it is up for some hearing. I prayed for that only.
Because that issue will come first.
The different subject matter, how different course of action, different complainant.
If I succeed, then he can come and challenge the inquiry report.
You're flogging a dead horse.
No, therefore, I'm not pressing, my lord. I'm not pressing for hearing, final hearing. Heaven will not fall down, my matter will be taken up after vacation. Otherwise, I deserve some kind of hearing, my lord.
He's trying to reserve one fruit like to be eaten later. Suppose anything happens.
No, that is different.
That cannot be accepted, my lord.
Different allegation. How can different offence? Well, it cannot be, my lord.
The only thing is, Mr. Sagreso is reluctant to be heard today, so I can't open his mouth for him.
I bow down and pray for some kind of hearing.
Discretion of this court.
But you do your best. I see, Mr. Nombre has to sharpen his wits.
He wants to face only one inquiry.
Well,
No, different inquiry, man.
It could be different.
Without hearing, my lord.
There has to be a balance for everything.
Well, you see, as far as I see, of course, I have to go through the records. I have not gone through them, but in my opinion, once one chapter is closed, it stands closed. Now he's on to he's on to the next. Now it's the next disposition. So you have to look at it that way.
Absolutely.
I only humbly prayed for give me some time for some hearing. Only.
On pre-made by the Leonard Senior Counsel for the petitioner, this is matter of petition.
I don't.
Item number 3.
Dan hearing apa ke hearing part sorry.
Illustrative, in this case, I filed my affidavit. Illustrative.
Yes. Oh, that contempt matter. What is your?
So, Illustrative, my stand is.
Are you saying that
we have taken with the ministry of this matter?
Your Lordship, he's filed an affidavit going back to the merits. So
No,
will not look into all
Illustrative,
that.
paragraph
But
5
let me submit. They've made a specific pleadings in their affidavit, Your Lordship. I'll take Your Lordship to that. Paragraph 4, Your Lordship, page 6. Paragraph 4, page 6.
Yes.
411. The respondent authority has already taken up the matter with MHA, and the same is under process at the end. Recent MHA correspondence dated 18 September 23 be placed on record for perusal of the Honorable High Court. Now we'll go to Annexure R4, Your Lordship.
Which?
I'll just take Your Lordship. Which was that?
110 page.
Page?
100?
110.
110, Your Lordship. R4. 110. Annexure R4.
Yes.
I'll read, Your Lordship. Implementation of Common Judgment Order dated 17 February 2023, passed in WPC 198/2019, filed by Sri Ajay Kumar and 191 others of Assam Rifles. Reference Assam Rifles letter dated so-and-so, dated 24/4/2023 on the subject cited above. Assam Rifles is requested to provide following details information of these 202, 192 petitioners and 10 non-petitioners superseded Havildar's clerk. Number 3. Similar details in respect of 89 personals who benefited by judgment and order dated 12/10/2018 passed by an Honorable High Court of Meghalaya. Now number 4 is important, Your Lordship. Further, the Assam Rifles is requested to file a misapplication in the High Court of Meghalaya judgment and order dated 17 Feb 2023 passed by Your Lordship. Passed in writ petition number 198 of 2019 filed by Ajay Kumar 191 others for seeking sufficient time to process the case. That, in my humble understanding, Your Lordship, they have admitted. Now it's in their hands to implement.
Yes,
Now it's just a matter of Your Lordship granting a little bit more time to them to implement the judgment.
In effect, you see what Mr. Devnath has submitted. This paragraph 4 will suffice. He says that it's under process.
Yes.
That is the word used. So we'll give him time.
Well, some time may be given, and then if they don't do it, then we'll be at their perils.
Heard Mr. R. Devnath, who has submitted that the affidavit on behalf of the respondent, Contempt has been filed. On perusal of the said affidavit, at paragraph 411, the same has been averred. The same has been averred, which is reproduced below as reproducing anymore. Mr. Devnath has submitted that the case of the petitioners is under is or R.
R.
Are under whether no actually it'll be a common order in any case. Is under process, and as such some time is required for the respondent
to implement
complete the process. At this juncture, it would not be. It could, no conclusion could be reached as to the fate of this instant petition. Be that as it may, the respondent contender is hereby given the time as sought for. It is made clear that the said process should be proceeded expeditiously, and a report to be filed before this court on completion of the same. As prayed for, this is matter of application.
Item number 4.
My lord, case record was called for. The relevant person was called for the statement of the accused under section, co-accused and recorded under section 164. But your lordship, there is no such statement made by the accused before the magistrate. 164 statement, there is nothing, your lordship. So, and there is also no disclosure statement. And my lord, without going to the merit, your lordship, this quantity is intermediate quantity, your lordship, and the accused, he has been in custody for last 10 months. He is 20 years of age. And your lordship, 4 witnesses have already been examined. And your lordship has...
I think, okay, have you produced the deposition of those?
Yes, I have enclosed, your lordship. All 4 witnesses are hearsay witness.
Okay.
They have...
You have enclosed?
Yes, I have enclosed. And I have also supplied the judgment also, your lordship has already held in cases. So it is fit in my case also, it is applicable, your lordship.
The CD has been produced?
Lordship, as per the last order passed by this Honourable Court, Lordship, we have received this WT, Lordship.
So this, in effect, is directing the court to...
No, Lordship, not the court, the prosecution, Lordship.
And you should have done it. Have
Lordship,
you done
but
it?
we received that just... So, Lordship, that's why I placed this before this Honourable Court, so that if we may be given the opportunity to get it from the trial court, Lordship. We've applied for the documents, Lordship, they're yet to come.
This court is made to understand that the prosecution as a whole,
Lordship,
is a system,
Lordship,
in
Lordship,
place, interlinked, interconnected.
my lord.
Now, if one part says, no, I've done my duty, it's for you to, other part to look into it. That's
No, my lord, what the reason why I
moment
placed this...
The moment the order is received,
Lordship,
they should have processed it, made, either verbal or written correspondence or communication
Lordship,
with whoever is concerned,
my lord,
and then get it done.
Lordship.
This is not the way it should be.
My lord, my apologies firstly. Secondly, my lord, I placed this before this Honourable Court is that we are yet to receive the request, my lord, because we have contacted, Lordship.
I may not, I'm not blaming you personally,
Lordship.
but this incumbent upon any responsible officer to apply his or her mind.
Lordship. My lord, we'll resolve that problem, Lordship.
Is for you to ensure that finally
Lordship.
whatever is asked for is given.
My lord.
Now unnecessarily, and this is a bail matter.
Lordship.
1 day is wasted, or rather 2-3 days, whatever the case may be.
Lordship. Lordship, we have asked for the request, Lordship. It is still in transit, if I'm not mistaken.
We'll take up this matter on Friday then.
My lord, much obliged, Lordship.
Ms. Sanjeev Leonard Sineji has submitted that the case diary could not be produced today and has prayed for some more time for the same to be produced. On permit, the same is allowed. This matter on Friday.
Lordship. My lord, if I may have the WT back, my lord, I can take the... Much obliged, Lordship.
Item number 5.
Lordship, in this matter, Lordship, I have met the IO, and Lordship, he came with a copy of the charge sheet only. And I was told by him that he has submitted the case diary in the court. So,
commercial quantity?
Commercial quantity, Lordship, yes.
But nothing was found from my position, Lordship. Even I was not there also.
What is the stage of the case?
Charge sheet case.
CC, Lordship. Consideration of charge.
Commercial quantity, Lordship.
And how is your
They have linked me with this case because of one mobile number. which was never seized from me, Lordship.
And those are all matters of those are all matters of evidence.
Lordship, I'll satisfy Lordship. I may be allowed to submit, Lordship.
Lordship, as per the FIR, Lordship, he is the supplier. And during the investigation, these co-accused from whose possession the contraband was recovered, they have mentioned his name.
But Lordship,
he's
supplier. To one thing, judgment, Lordship, the statement made by the co-accused is inadmissible.
It is inadmissible. That is true.
So, Lordship,
but all those things will have to be taken into account only at the trial. As far as bail is concerned, we are still governed by the provisions of Section 37.
Lordship, Lordship, I will satisfy, Lordship. I may be allowed to submit, Lordship.
Go next.
I don't think we'll. On pre-made by the Leonard additional PP who has submitted that the case diary could not be produced today.
Lordship, I have met him and he came with a copy of the charge sheet only. So a clear election may be given to him and to the...
It's for you to see. What is the... See, look at the order. Yes. What does the order say? The order says that you have to submit the case diary.
Yes, Lord.
How you explain to him, that's up to you.
I have explained to him to give me the case diary, but he said he has submitted in the court. Let it be to the additional SP also, Lord, direction. Because the additional SP also contacted me over the phone.
You have to use your authority on that. You cannot expect the
additional
SP
also
court to do everything for you.
He contacted me on the phone and he said we have submitted a charge sheet. And once we have submitted a charge sheet, we don't have any authority anymore.
Have you noticed the observation of this court in the earlier case?
Yes, Lordship, I have seen, Lordship.
You cannot shirk,
but I have tried, Lordship, to
shirk your responsibility.
I have tried, Lordship. Additional SP also I have told him. But he said we don't have the case diary now. Once we have submitted in the court, it means we don't have any copy. That direction be given.
I pass the order. Whether you produce it or not, it's up to you. On pre-made, this is matter on 11, on 13th.
Lordship, direction may be given to the additional.
Direction has been given. It's up to you.
Item number 6.
Yes.
I request some more time, Lordship, to file my affidavit. I'll file it before.
You are appearing for respondent?
I'm appearing for respondent number 2 and 3, Lordship. 4, 1.
On pre-made by.
Matters between the private parties, so we have to think down whether we should file affidavit or not.
You are a collector.
They have made allegation that the district collector has released the money fraudulently. I think so. They should file.
Then, if you don't file, then you don't file, then it goes admitted. Anyway, on pre-made by the respective counsel for the respondent, who has sought for some more time to file the counter affidavit, the same is allowed. Let the counter affidavit be filed within the next date fix. This is matter after 2 weeks.
Right.
Hearing now. You call up on.
Item number 8.
Yes, miss.
May I please, Your Lordship, in this matter, I need some more time, Your Lordship.
2017 matter.
Yes, Your Lordship, because Mr. SD is arguing this matter, so he's having some personal difficulties.
So the last day, Mr. Dave appeared, Lordship. He argued this matter. Most of the dates, Mr. Dave appeared.
But he's handling the matter, Your Lordship. He's as per his instruction only. We'll be arguing the matters in the next Lordship.
That affidavit also I have filed.
But Mr. Karmi, you are supposed to file.
Yes, I have filed, Lordship. I have
you
filed.
filed.
I have given them the copy.
You've given a copy.
I have filed. I have already filed.
So now it's for them to respond.
It's just the instruction, Lordship. No need to respond also. Okay. It's not affidavit, no question.
What is the procedure?
Yes.
Oh, that is
Criteria.
There's no procedure.
criteria for the
yes.
Yes, expert body in the interview board. On pre-made by petitioner, this is matter of the petition.
Item number 13.
Here.
May it please Your Lordship, the learned DGI is still on legs, Your Lordship, if the matter may be taken up after DV, Your Lordship.
Yeah, we'll take it out after DV.
Supplementary cost list, item number 1.
Yeah, please, Your Lordship. Your Lordship, the respondent, Gopal Dev, he have verbally informed us to appear in this matter. Your Lordship, he'll be sending the Wakalatnama through speed post as such. And I'm further praying that I may be allowed to file objection to the condemnation of delay application.
Oh, it's an application for condemnation of delay?
Yes, it's a miss case, Your Lordship.
How many days?
90 days, Lordship.
Miss PG3, Leonard Council, has submitted that the respondent has instructed her to appear in this case. However, the power could not be filed today. It is prayed that some time may be allowed for the respondent to appear, to be represented, and to respond to the application for condemnation of delay filed by the applicant, Union of India. On preambit, I think we'll have to pause it after vacation.
Delay of only 90 days, I don't know.
Do you want to
file an
respond?
objection to that one?
I'm instructed by my
This is matter of 2 weeks.
Oblige, Lordship.
From daily cost list, item number 1. Second call from supplementary cause list, item number 2.
So first we are on the calculation of the days, number of days.
Yes.
As far as authorities are concerned, I don't think we need to go any further.
Yes,
if we are entitled to default bail, the Rakesh Paul case is there.
Yes,
So
only the date.
the only thing is how do we
Calculate.
Yes, Dr. Muzika, have you done your calculation?
But one aspect, whether the date of remand will be included or excluded. So now very recent decision of Supreme Court, this is in 2023. The Supreme Court has said the date of remand has to be included. So date of remand, I will not dispute that part.
So that would be 25th. What is the date?
24th.
24th of May.
May, yes.
Is the order annexed here? So we remanded on 24th.
24th. Annexure. Annexure.
He was remanded on 24/5 ballot.
So 24/5 till
19/11, 180 days.
So till we go till 19 or we go till 20th?
19/11, Your Lordship, completed 180. 19/11. 19/11 completed 180 days.
180. Okay. And charge sheet was filed on 20th. 181.
Yes.
So now the only question is, my lord, if charge sheet and bail application both are filed on the same date, what will be the consequence?
But I filed first.
If charge sheet and bail application is filed, then
are filed on the same date.
Yeah, then it is considered that the charge sheet has been filed.
That is
if it falls, if it falls above, I mean within that 180 days.
180 days. But here 181 days.
But here it is 181 days.
1 day.
Excuse me.
No, my lord, that will not be very relevant, my lord. Because that 180th day was a Sunday, my lord. So 180th day being a Sunday, he also could not file his bail application on 180 day, my lord. He filed next day. We also filed our charge sheet on the next day. Now the question here, my lord, I'll place.
Yes. Now only on that, that issue would be relevant. As to whether it would be considered the next working day, or it should be considered, exactly, precisely 180 days.
180 days, Your Lordship. Because there is no inclusion or exclusion of Sunday or Saturday or holidays as in the 167. It is exactly from what it says. In Rakesh Paul also it has been held, and other judgment also that exact date has to be.
So I have not come across any judgment.
My lord, I have one Guwahati very recent decision, my lord, of February 23. In a similar circumstances, on the same day, if charge sheet is filed, before bail is granted, my lord. If bail application is considered, bail bond may be executed later, my lord. But if bail application has been heard, the learned magistrate has applied his mind, and if by then charge sheet has been filed, my lord, then the default bail stage will be over, my lord. I'll place some decisions on that.
My contention was that, Your Lordship, that my application was not at all taken. That is.
No, that is altogether different thing, my lord. If he wants to file a fresh application now, not raising the ground of default bail.
No, I am on default bail only, Your Lordship.
So if my friend is only on default bail, my lord, I just place two decisions, my lord. One of Guwahati High Court.
If they can show, Your Lordship, that yes, they filed prior to my application, then at least.
It's not necessary, my lord. A day will be taken as the day, my lord. The time, whether we filed half an hour before or after. But if it is filed
within the 24 hours.
But if it is filed before the bail application has been heard and order passed therein, my lord, that is enough, my lord. What Supreme Court also said, High Court also said, my lord.
My lord, my bail application, I have filed the bail application in time.
My lord, even if you take that, it was 180th day, my lord. One day we have not exceeded. Now on one day, this situation can arise, my lord. On 180th day, in morning 10 o'clock, he files a bail application, my lord. And by 12 o'clock, prosecution files a charge sheet, for example, my lord. Even in then, my lord, if bail application is not heard and order passed therein by then, my lord, before the filing of the charge sheet, Supreme Court and High Court say then the charge sheet has to be considered and bail order has to be passed on merit, not on default.
See, Mr. Dr. Muzika, if you recall that Rakesh Paul judgment, there was an observation there, or rather there is an observation there made by, I think, Justice Rukur, that as regard default bail, if that period, has not yet been...
At 12 o'clock night, that period is over, my lord.
Period is not yet over.
My lord.
It is incumbent upon the magistrate concerned to inform
yes, Lord.
The accused that you are entitled.
Yes, that was my concern.
If he does not do so,
my lord,
he will be held responsible.
My lord, that situation in this case will come on Monday, my lord, because Sunday courts are closed, my lord. So Monday, they are already there with bail application, my lord.
Your lord.
Yeah, that is true. So they are aware of this.
They are aware of this.
No, we are not aware of that. Charge sheet copy was also not given us. Complaint copy was also not given us. And even if your lordship, the date falls on production date, even on Sunday the accused they is to be produced. That is because deputy magistrate is always there.
Page 19, your lordship says, my lord, his application, page 19. You know? The cause title, my lord, an application under section so and so read with so and so for grant of default bail, my lord.
You are referring to?
Page 19, my lord.
19 of the
petition.
Yes.
Also, would you please, this Guwahati High Court decision, very recent decision. Para 10.
Para
10.
10.
Yes. It says, thus, from the herein above quoted decision of the Supreme Court of India, it is evident that once a charge sheet is filed, even after the expiry of default period, and no bail application is pending prior to the said filing, the accused would become entitled to default bail. In the present case, it appears from the contents of the order dated 4/11/22 passed by the learned court below, that the charge sheet by the IO as well as the bail application number so and so by the petitioner were both filed before the court of the learned special judge Kokrajhar on 4/11/22. Therefore, as charge sheet had been filed on 4/11/22, we are unable to hold that the learned court of special judge Kokrajhar is committed an error in rejecting the prayer for default bail.
This is understandable. What the court has done here is
not even accepted.
The charge sheet has been taken into cognizance. So the moment the charge sheet has been taken into cognizance, the
167 goes, my lord.
The principle of default bill.
Yes, it goes. I also admit. Yes.
That's true.
Yes.
So therefore, the bill, application was not considered.
No, my lord.
As far as this case is concerned.
Yes. Is that
because it was filed on the same day.
Same day. Yes.
Charge sheet was filed. Yes. Yeah, that's true.
That is true.
There's no.
There is no. My lord, only in Rakesh Paul, the Honorable Supreme Court has held that it could not be frustrated, that it is a fundamental right, it should not be frustrated by any means, indivisible right. So, I should also get.
But there is, you see, nothing on record that you are.
That is the thing, Your Lordship. I have.
What do we do now? It is your word against the system.
But charge sheet copy was also not supplied to us.
No, we are not talking about. You are referring to an bail application filed prior to.
Yes, charge sheet.
Prior to filing of the.
Yes.
Which was not taken on board.
It was not even registered. That is what I am in such situation, Your Lordship, that I cannot cast anything, Your Lordship.
That is true.
Non-registration is I don't think that is a practice followed here, my lord, but I don't think that's a
This
correct
is now,
practice.
Your Lordship, order is also not uploaded in the e-code on 2021. That's why we filed on 22nd, 21st also it was no order was passed that it has been. That I cannot, Your Lordship, I cannot say much because it is very difficult for me.
Well, the
also.
filing is done in the registry, but the practice followed that registry sends the application to court
From
first.
what I could understand, what Mr. Pandit was saying, is he takes the petition, goes to the registration counter or whatever, and say, "This is my petition." They say, "No, we don't have time, or we can't. You go."
Yes.
If somebody says that, that's his word.
Yes, Your Lordship.
So now,
Well, what I understand, what happens, especially in Shillong, my lord, the registry says they go to the magistrate,
there
and
is
there's
no
a
such
small
practice.
signature.
that is that for the put up order and all this.
Now that practice has gone, Your Lordship. There is no such thing practice in Shillong. After
This
this
is in
e-code,
Shillong?
no, this is Nongpo. After this practice, this e-code and all this thing has come, Your Lordship. They used to register But in my case in Nongpo, they said that you go first, and that petition was kept for long. 2:30 I was informed that you take your petition because date of remand has to be included, and that's why she written that on the contention that I said at least my petition will be registered and my argument will be heard, and then so that I can challenge or whatever I can do. But so many things were
defects were pointed out.
Yes, that I have stated also that 180 days not completed as per the learned trial code. Date of remand has to be excluded.
But there is no judicial order to that.
No, that is the thing. What option I have? What option I will have, Your Lordship? Should I file anything that I don't want? I want relief.
Very, very peculiar situation.
In fact, what court should have done, taken the application, pass a judicial order that is one. It is beyond. It is not. So that was done.
Now, let's assume that his statement is correct. So the fault will lie with the the office concerned or the registry concerned. But there is no proof to that.
No proof.
It's his word against their word.
Yes, that's why I'm relying on that Rakesh Paul. At least magistrate is duty bound to inform, even on Sunday when this duty magistrate is there, production day.
No, you see, it implies that the magistrate is duty bound to inform when the matter is put up.
Yes, yes. That anyway.
That was not the day of remand, as you rightly said. The day of remand was 2 days prior to.
Yes, Your Lordship.
So.
Even that also, Your Lordship.
And that you see, on that day, 180 days has not yet expired.
Before 2 days, yes, Your Lordship. That is the only.
Then another situation has arisen, which goes against you.
Yes, Your Lordship.
So you can't.
No, that one I'm not.
You can't fault
yes,
the magistrate for that.
Only in this situation, Your Lordship, I think.
What I'm concerned is, if what you say is correct, you have filed an application prior to the 180 days seeking default bail,
yes.
And will not say the court,
not
but the registry refuses to
register.
What do we do? For all we know, you might also, may have made a false statement also.
Yes.
You might just have come up with a story that, okay, I'll present this story to the court.
Yes, that
it could be. It works both ways.
Yes. PP has. I have, Your Lordship, I have enclosed the application also where PP has himself received the copy also. Endorsement is also there.
No, that
endorsement is also there. He also did not inform me when we received
the previous. Where is that?
In the application, I have page number 19. He received the application also. My application.
Oh, this is the one.
Yes, in the body of the petition, he received.
But this is 20 or 21 is not clear.
No, a second petition also is there. There are two petitions. Your Lordship, 24, page number 24. That much.
This is 21.
This is
no, 20, Your Lordship.
No, this one.
Yes. 20. This jail officer also has signed, and I placed it. And then second petition also, Your Lordship, 24, page number 24, for both the accused, and 2011, 2023. He received. That much false statement I will not make, Your Lordship, for just for. He received on 2011. Both the application I have given him.
But the law now, my lord, says that if both are pending on the same day which charge sheet is filed and so bail application is filed, my lord, if an order has already been passed, my lord, there may be a situation that 10 o'clock bail application was filed, it was heard at 11 o'clock, order passed that you are hereby granted default bail. Bail bond, it doesn't matter, my lord, bail bond you can sign by evening. And supposing that we file charge sheet by 12 o'clock, by 1 o'clock, 12 o'clock order has already been passed, my lord, then he is entitled to default bail, my lord. But at the time when bail application is heard, for example, bail application was heard at 2 o'clock, my lord, of that day, and we already filed charge sheet at 1 o'clock, my lord, then 167(2) default bail will not apply, my lord. That is what.
No, that is accepted, my lord. See, that is accepted. We are not. You see, like I said, the observation of the Honorable Gauti High Court is accepted. If simultaneously on the same day, like you said, see, time, see, it does not matter. But at the time when the court passes the order, it has taken cognizance of the charge sheet being filed. Then
the question of default bail doesn't arise.
As was perhaps was done in this case, or we don't. But the fact remains that the petitioner says that the application was filed prior to.
Yes, Your Lordship.
The court has not taken note of it.
But on the same day, my lord. Maybe prior in point of time, maybe by 11 o'clock he filed, my lord. A charge sheet was filed
on the same day.
On the same day. It's not on the prior day.
Oh, this is 20th. So that was on the
time is matter.
180 days.
181 days that day.
181.
Yes.
180 days will be over on
Sunday.
The 12 o'clock midnight, my lord. Sunday midnight. So from there, 181 days starts, my lord. Then morning happens, my lord. Then he comes and files a bail application. We do not know, my lord. Going by his submission that he filed at 10 o'clock, we do not know, my lord. At what time who received, it is quite possible that we filed charge sheet first and he filed a bail application later. That is also quite possible, my lord. We don't have any evidence to that effect. But irrespective of that, my lord, if by the time bail application is taken up, charge sheet is on record, my lord, the court cannot grant default bail.
Yes, it's true.
Now, but here is the situation is that his bail application was not accepted, not registered. So that
as far as the 181 day is concerned,
yes.
So your bail application was not
entertained. If Your Lordship,
but even then,
copy also not served to us. If charge sheet is filed, we were present. Copy also not served. If the charge sheet was filed in time.
See, you are not serve a copy immediately.
Yes.
See, when charge sheet is filed, usually the court take cognizance of it, record it in its order. The charge sheet has been filed. Then okay. On the next date.
Yes, that is okay.
Fix for copies.
Yes,
that order is usually passed. So it's not necessary for you to receive a charge sheet. But the only thing is that you are to be conscious of the date.
Yes, the charge sheet. Yes.
You may come to know of it later or.
Yes, later or yes. Oh, yes, that is okay. But here, Your Lordship, my senior has submitted that on the same day, if both are filed, but time doesn't matter.
So in that case, as far as your case is concerned, see, that issue will not arise.
Here issue will arise who has filed first.
No. If on the same day,
if it is on the same day,
yes.
Even if you file first,
yes.
Then that judgment will hold.
No. Your Lordship, here in Rakesh Paul, it has said that if 72, if two meanings could be attributed to such a provision, then the court must lean towards liberty and accept that interpretation of the statute which upholds the liberty of citizen and which keeps the eternal flame of liberty alive. 72. So it should be interpreted in my favor, which upholds the liberty if this situation has come up. So the court must lean towards, because it is says that 167 provision is a fundamental right. So the court must lean towards me. In Rakesh Paul case, Your Lordship, I have given 72. So the court, my
But
lord,
rather-
I should
my lord,
not be deprived of my
in my humble submission,
on
my lord,
technical.
he's
It
not
is
entitled
also
to default bail, my lord. I have one Supreme Court decision also, my lord, where it has been held in a similar line, my lord. And that has been referred to in that Guwahati decision also. My lord.
What is it?
But in this Guwahati decision, if I can just
time is essence.
Have you given the list of
I just place one judgment, Your Lordship.
the Rakesh Paul judgment?
Yes, sir.
I don't remember the citation.
नहीं ठीक दिया तो
This is this talks about the day of remand.
yes, yes.
There's no dispute as far as that is concerned.
Time, Your Lordship, time. It is.
This is the latest decision on the date of remand, my lord. This is just judgment passed by Justice Rishikesh Roy.
Yes, this is the one.
2023, my lord.
Yes.
Yes, ma'am. Enforcement Directorate versus Kapil Wadhwan.
Yes, this is the one. Yes. What is it? Yes, that's what. What's the relevant para here?
My lord, para 53, my lord.
53.
53? Oh.
53, my lord.
I think yours is, what is your?
My one
Your
is
journal is?
live law.
Your journal is what?
SSC online.
SSC online. And
I'll just point
you're
out.
giving me live law, I know.
Yes, I don't
Is
have
it-
Your Lordship.
Which one is this? Satish Wadhwan?
This is कौन सा है सर देखिए देखिए रिजिस को सुना ना
Is this a
Enforcement
valid?
director Kapil
Is this a valid journal?
side this is
I know.
53, 53. This one.
नहीं मेरा में अलग है
It will be same only. Para 50 है.
इसमें 50 है नहीं इसमें हम दिख रहे हैं ना
Yes. What does it say?
Since there exists vacuum, Lordship's got.
Yes, yes.
It says, well, since there exists vacuum in the application and details of section 167 CRPC, we have opted for an interpretation which advances the cause of personal liberty. The accused herein were remanded on 14/5/2020, and as such, the charge sheet ought to have been filed on or before 12/7/2020, that is 60th day. But the same was filed only on 13/7/2020, which was 61st day of their custody. Therefore, the right of default bail accrued to the accused person on 13/7/2020 at 12 a.m. midnight onwards. On that very day, the accused filed their default bail application at 8:53 a.m. The ED filed the charge sheet later in the day at 11:15 a.m. Thus, the default bail applications were filed well before the charge sheet. In Ravindran and so, which followed the Constitution bench in Sanjay Dutt, it was rightly held that if the accused person availed their individual right to default bail before the charge sheet final report is filed, then such right would not stand frustrated or extinguished by any such subsequent filing. We therefore declare that the stipulated 60-90 day remand period under section 167 CRPC ought to be computed from the date when a magistrate authorized remand. If the first day of remand is excluded, the remand period, as you notice, will extend beyond the permitted 60-90 days and period consulted, resulting in unauthorized detention beyond the period envisaged under section 167 CRPC. In cases where the charge sheet final report is filed on or after the 61st or 91st day, the accused, in our considered opinion, would be entitled to default bail. In other words, the very moment the stipulated 60-90 day remand period expires, an indefeasible right to default bail accrues to the accused. Following the above discussion of the improved orders on.
No, this is, I think there's no quarrel.
There's no quarrel. Malab, this is only that date of remand should be excluded in counting 60 or 90 or 180 days. Malab.
What we are talking about, you are referring to the Guwahati judgment, which talks about the same day when bail application and charge sheet was filed.
That is also, Your Lordship, prior to the said filing, it is written. if no bail application is pending prior to the said filing. That also.
No, this talks about the filing of bail application and charge sheet on the same day, 4/11/2022.
Yes, ma'am.
It says that Hrotas from the herein above quoted provision of Supreme Court, it is evident that once charge sheet is filed, even after the expiry of default bail, once charge sheet is filed and no bail petition is pending prior to the said filing,
Yes.
if there is no bail pending, or in the present case it appears from the content of the passed by the London charge sheet of the Iowa as well as bail application by the petitioner were both filed before the court. Therefore, as charge sheet had been filed on 4, we are unable to hold that the learned court for special judge had committed. This is 22, but now your lordship this.
So as on 19,
Yes, sir.
1911, no bail application is pending.
On 19, no bail application was pending.
So on 20th.
28.
So now, if you had filed the bail application on 20th.
Yes.
Hmm.
Yes.
They have also charge sheet was also filed on 20th.
20th.
Then this Guwahati High Court, order will.
But your lordship, this judgment, which this 23, this enforcement ED, it talks about time, your lordship, because who has filed first? Even if on the same day, this is 3 judge.
You're talking about this Supreme Court judgment.
Yes, your lordship.
No, we're not talking about that.
Yes.
Because Supreme Court judgment says only about it has taken into consideration only the aspect of the date of remand.
Remand.
See, so, but this here it just says that if there is a bail application,
pending.
file on the same day the charge sheet was filed.
Yes, your lordship.
Then the rejection of the application for default bail is valid. That's what this order, paragraph
Order,
says.
yes, your lordship. But
So if
yes.
in your case also it comes to the same thing then.
But your lordship, this Supreme Court, it is specifically mentioned here that second judgment ED, that time it was filed on 8:53, means 9 o'clock, and charge sheet was filed 11:15. So they have taken into consideration the bail application before charge sheet. If had it been the case, your lordship, that in the order if it is reflected that yes, charge sheet filed on such and such and time was also mentioned, then I would have not agitated this point. But it by any means, your lordship, the my indivisible right should not be curtailed on this technical aspect of the
There is
matter.
no practice here, as far as Meghalaya is
Yes, your
concerned,
lordship.
to note the
Note the time. In such situation, your lordship, in such situation, because this has come very.
If that is the case, you see, what we have to take is, it should be working hours.
Yes, your lordship.
The time would be 10 to 5.
Yes.
So within that period, if you have filed, you have filed. So there is no indication to say that you have filed at 10
and they
filed
filed
at 11, or you have filed at 11, they filed at 10. It's nothing. So in such a situation,
but
this Guwahati High Court order will stand.
Your lordship, because this, I think, time, my submission may be recorded, your lordship, because I fail to understand, your lordship, why they have not, because my petition was written at 2:30, it was kept, and then.
In any case, yes, another aspect of that, we are on the assumption that your bail application was filed on 20th.
20th, yes.
So that we have, we are taking that into consideration. But the fact remains that there was no bail application as on 20th, because it has already been returned.
Yes.
So again, see, if you had filed on 21st, then it has become futile. Because by then, you see, on 20th, the charge sheet has already been filed.
Then in that case, Your Lordship, I am deprived of my right because of the process.
Nothing
And
can be
then,
done.
and then, Lordship, this Rakesh Paul has said that it cannot be frustrated. This indivisible right could not be frustrated by any technical means.
We cannot. It's not a question of technical issues here. It's not a question of technical. It's a question of unexplained circumstances, which the court, cannot extend its imagination to favor you. I don't think so.
Your Lordship.
I think at best you have to. At best you have to argue on merits.
On subsequent date also, when production was there, Lordship, no copy was supplied to us.
Oh, that is
on subsequent date also.
That will be.
And
copies usually are not
on,
prepared.
Your Lordship, may kindly come to page number 18 of my petition. Annexure 3.
Yes.
Your Lordship, on 17/11 they were produced, and Your Lordship may come this second paragraph. Scene remand report dated 17/11, submitted by the seizing officer Sri such and such for remanding the accused person to 14 days judicial custody so as to enable him to complete investigation into the case. On 17/11 they asked for 14 days, another period. And Saturday, Sunday it was completed.
Yeah, doesn't
That-
matter. Doesn't matter.
And then Your Lordship, it was allowed also remand beyond 180 days.
Yes.
And 364A says that it cannot be unless public prosecutor file an application for extending the remand. It amounts to automatic extension of the remand beyond 180 days. That also is violative. And then my petition was on 21st.
Even then, you see, Mr. Pandit, even if an order is passed for your remand beyond the 180 days,
Yes,
if no charge sheet has been filed, you are still at liberty to come before the
for
court.
default bail.
That would be covered.
I just wanted to impress upon the court that within 2 days how they have filed the charge sheet also.
Can be. There is no specific time frame
Taken to, yes, that is.
Anytime he completed,
He
the
can
investigation, he
place
files the charge.
Yes, yes. But only on contention that, Your Lordship, my petition was filed well within before the charge sheet. I have specifically mentioned that it was filed, and then that petition I have said that it was not registered. It was
This court cannot go into that now.
My lord, in fact, the entire aspect, whatever the contention, my lord, I have not given that. We have given now, my lord. This is an important decision, my lord. Para 22 and 23 of this decision.
What?
This aspect has gone very high, my lord. But there are many important decisions on this. On this aspect only, on the same date, both are filed. Then what will happen?
When the bail application and the charge sheet filed, we will accept.
But in fact, what I am citing now, my lord, from Supreme Court, that will further reinforce, my lord.
The court will accept that. Even Mr. Pandit has accepted that. The only thing now we are talking is the issue of time. Which comes first? Whether the bail application was.
My lord, if I point out that even that is not relevant, my lord.
Okay.
If at the time when magistrate was considering or has to consider the bail application, normally bail applications are taken up in the second half, my lord, in Meghalaya. Even if you file the bail application at 10 o'clock, if 2:30 bail application is taken and by then charge sheet is filed, my lord, this is what this will be.
Yes, of course.
That is okay, but the thing is that my bail application, any order, it could have been rejected, it could have been indicated in the order that yes, it should not be included, or you have filed, you have come late, everything, but it should not be oral, it should be on, it has to be on record.
But this, see, again we come back to the same thing again and again. There's nothing on record to substantiate your contention. So I understand your plight, but this court
This will
cannot.
only encourage your lordship.
This court cannot.
If I have come before your lordship.
True, but the court cannot venture into
all these allegations,
into a
of
realm
course.
of speculation.
Yes.
Because that is casting aspersion.
Yeah, I understand your lordship.
On the
judicial.
of the court.
That is, but only
without any concrete evidence, it just cannot be. Because you see, in all, for all practical purposes, courts are considered to be fair.
Yes,
they have to act fairly. So that is why we are here. We have also given an oath to that effect. So unless there's no
if they will dispute your lordship that I have not filed, then of course, but they admitted on yesterday also that yes, and receive also there whatever I have said, but only
no, I'm not admitting, I'm not denying, but I have no information.
No, you see, what you said is correct. You see, yes. Copy must have been advance copy may have been given to the PP.
Yes,
fine, yes. That's true, but the actual filing was not done. You say that you have done, you have gone, and it has been rejected because of technical or typographical or whatever error for you to correct. But the fact remains that there is no evidence of it. Had there been some electronic evidence, kind of an e-filing is prevalent now.
Yes, yes. If they used to register in e-court and all these things.
No, e-filing is not there.
Oh, e-filing is not there. E-filing is not there.
Could have been. That could have solved the problem. I think Mr. Pandit, I'm very sorry, I cannot help you.
So, Your Lordship, then in that case, I have to go on merit. Let me file before the trial court first.
Can you withdraw this petition? Practically, because as far as default bill is concerned, I think withdraw this way, but you can always file, immediately file a fresh petition tomorrow. The matter will be taken up on merit.
You can go back to trial court also first.
Yes, you can go back to trial court.
Your Lordship, then liberty may be given to file bail application before the trial court. Otherwise, if there is no direction, it is very problem for us.
Fine, I'll give you.
And the learned trial court may be directed to
peculiar situation that you are in. If what you said is really correct, then of course. Otherwise,
the learned trial
court will not give you that liberty because it's your own right.
My right.
It's your right.
Liberty to file bail application before the learned trial court, and the learned trial court shall entertain and consider on merit.
We'll look into this issue at an opportune time.
Yes, Your Lord.
Heard Mr. S. Pandit, learned counsel for the petitioner, who has submitted that he may be allowed to withdraw this petition with liberty to file a fresh application before the trial court. The prayer not being objected to by the learned TSGI, the same is allowed. Petition is dismissed as withdrawn with liberty sought for. Allowed.
Before the learned trial court, I will file, Your Lordship.
Yeah, before this. Kapkayu, the trial court records are hereby returned. Returned forthwith. When is the next date fixed for this case? Next date is?
15, I think. 15 of December. 15 December.
Right.
Prior to that, I can file always tomorrow, day after also. Yours.
Yeah, we can do.